The centre has submitted a list of 627 black money account holders, commonly known as the HSBC list, to the Supreme Court. 3 sealed envelopes have been handed over to the Apex Court. The first with details of bilateral treaties with the other countries, the second with the actual list, while the third contains a status report on the probe into the case. The court, however, refused to open these sealed envelopes, saying that they would be forwarded to the chairman of the special investigative team set up to look into the black money case. The next hearing in the case would be in the first week of December, after the SIT turns in its status report on the 30th of November. The probe into all 627 names has to be completed by the 31st of March 2015. That is the deadline that the Supreme Court has in fact set for the SIT. The SIT has also been asked to share information with agencies like the Enforcement Directorate and the Central Bureau of Investigation, which, remember, was denied on previous occasions.
The SIT will open the sealed covers. The SIT will thereafter see what they have to do, and they will then proceed in accordance with law in whichever manner they desire. I had pointed out to the court that the same list, full and complete, had already been on 27th of June been given to the SIT, but the court has sent it again.
All right, my colleague Jaskirat Singh Bawa is joining me live for more. Jaskirat's been tracking developments for us from inside the Supreme Court. Jaskirat, it's been a dramatic, day of events. Many say a historical first step in the black money matter, but there are still several unanswered questions as to why that why that list has been given to the SIT by the Supreme Court now, when the government had already submitted the very same list on the 27th of June.
That's correct. Now, that is the question that is best answered by the bench itself. And the Chief Justice of India said and told the government yesterday that you just get the information and we'll pass it on to the concerned investigating agency. The question that was primarily being asked was, if the government is claiming that the SIT already has the list, then what new could perhaps be achieved?
Absolutely.
Is this a matter of perception, or is the Supreme Court trying to send out a message to the centre to indicate that since the SIT was set up as per our orders, we want to ensure that the investigation goes on without any interference of the government? But that again would be a pure speculation, because we really do not know what is going through the mind of the Supreme Court judges when they asked, or when they took upon themselves to pass on this list to the centre. What we do know is that the SIT now has a deadline from the Supreme Court. They have a deadline of the end of November for the status report and a deadline of March 2015 for the initial probe report. Why March 2015? Because the AG informed the court that under the tax laws, the limitation of action against the defaulters will end on March 2015, because there's only a limited retrospective action that can be taken against the defaulters.
Well, absolutely. That date of March 2015 is in fact very crucial. Right, Jaskirat Singh Bawa is still live with us. Jaskirat, what is also crucial is that the Supreme Court today has in fact directed the SIT to share the details with the Enforcement Directorate and the Central Bureau of Investigation, to bring them also in the purview of this investigation, something that was previously denied to them. Enforcement Directorate today coming out and confirming that. At the same time, the government has requested the Supreme Court to maintain confidentiality, because otherwise they would be in contravention with international treaties.
Absolutely. This was in fact an argument that was also mentioned by the Attorney General yesterday. However, we have learned that the existing treaties have come under a modification which now allow investigating agencies under, of course, a strict confidentiality measure to in fact be able to receive the list of the names so that they can conduct their investigations.
Right.
The only contravention here, or the only contention here, is that it should not be made public, and that is what the government was trying to tell the Supreme Court. Very importantly, something that indicates to us the importance of the SIT being elevated by the Supreme Court today is the fact that any hiccups or any questions or any problems that the government now has can now be made a representation of in front of the SIT. Specifically, the 7 ongoing discussions on treaties with foreign countries, including the United States. So the government can now go to the SIT and say that these are the problems that we have in our treaty negotiations because of the confidentiality clause, and the SIT can now take a call on that.
Well, absolutely, but this court order definitely puts a huge question on whether the order that has been passed today will serve as a hindrance to future tax treaties or not. Well, that's a question that still remains to be answered. Thanks, Jaskirat, for joining us with that update. We're going to continue to come back to you for more analysis and to break down what exactly has in fact happened today. The central government maintains that revelation of names in the black money list could put India at a severe disadvantage among the international community. The government's plea is that it can disclose names on black money list only after conducting probes on illegality of bank accounts, which was outrightly objected by the Supreme Court today. It brushed aside the contentions of the Attorney General that disclosing account holders' names would violate their right to privacy of those who have legitimate accounts.